So, lecture number 5, legal. So, Ed has, how long have you been with the lab now?
11 years.
11 years. Ed has, Ed's an amazing lawyer. He's been my lawyer for 10 years, perhaps, in various different businesses. He's very well respected in Nottingham and nationally. And he's going to go through some of the basics of law, things you need to know. So, a lot of you in here probably know Ed anyway, but Ed also does a monthly surgery, actually 2. So I will leave you with Ed, and then we'll do Q&As afterwards. Brilliant, thank you.
Okay, thanks, Steve. Morning, everyone. I presume all of you came to David Clarke's talk last Friday, in which he spoke primarily, I think, about patents, trademarks and designs, and the registration process involved in all of that. So I will not overlap with him. There may be some slides I quickly whip through on that basis, so that's the reason why. Okay, this is the sort of plan for the morning. I'm conscious there's a lot to get through, but we will stick to time. So moving on to intellectual property. The first form of intellectual property I want to deal with, which is one that in all likelihood David didn't touch upon because it's not something that patent attorneys have any particular involvement with, is a piece of intellectual property called copyright. Now, copyright's effectively an automatic protection that arises upon the expression of any ideas in any particular physical format or medium. It doesn't protect the idea itself, which would be understandable. Ideas emanating from anyone's mind should never be the property of that particular person. It could be conceivably an idea that's been had millions and millions of times over in different ways or different forms, but it would be ill-advised to make that a piece of property upon which someone could then capitalize commercially. But physically presenting it in some way, shape or form is entitling that person then to derive the benefit of copyright protection. It's not a monopoly right, and the reason is that conceivably two people based on opposite sides of the world without reference to each other or each other's works could generate exactly the same piece of copyright work, and it would derive copyright protection. Copyright is simply there to prevent copying. It's not there to prevent people from generating ideas, and those ideas could obviously be identical. And equally, it's highly likely that works that attract copyright protection may well have a number of copyrights in them, such as films or broadcasts or sound recordings or websites. When it comes to ownership, the owner, as you would imagine, the first owner, as you would imagine, is the author of the work, the party who actually goes about creating it. Now, in the context of employment, that is still the case. However, there is an automatic legal position, which is that despite an employee making a piece of work, the ownership and intellectual property terms of that work will vest automatically in the employer, unless there's an agreement to the contrary. And it's very rare that employment contracts contain anything to the contrary. So that's the employment position. It's an automatic entitlement for the employer to own the employee's rights in copyright works. When it comes to commissioning someone to do something in the context of web design, graphics, consultancy of any sort, software development, it's a very different kettle of fish. The party that's tasked with the job will own the intellectual property rights in what's created. Regardless of whether you pay money for the task that they're carrying out, they will still own the intellectual property rights in that end product, unless you get an express assignment of those rights in the contract that you have in place between you. So 2 things: get a contract in place between you. Second thing, make sure you're taking an assignment of the rights in what they create, if and to the extent at a practical level they can. I mean, software developers will have a lot of tools that they use. They may well have some underlying software that they've generated that they're adapting for your particular purpose. So there may be good reason they want to keep what is in effect their intellectual capital upon which they conduct their business, and understandably they wouldn't want to concede that to you. But in most other cases you should be looking to take a full assignment of copyright, and also you should be looking for the author to waive their moral rights. These are rights that attract to authorship, and they are principally the right of paternity, which is the right to have your name attached to a particular piece of work and credited as the author. The right of integrity, which is to prevent people from effectively conducting some sort of derogatory treatment of your work or adapting it or altering it in some way. And the other is the right not to have work falsely attributed to you. So, in conjunction with an assignment of copyright, you should always be looking to have a waiver of moral rights in the same document. Copyright lasts for a long time. It lasts generally for quite a long period of time after the death of the author. As you can see from this list, it's principally now harmonized to a position where it's the author's lifetime plus 70 years. In sound recording terms, it's generally 70 years from publication. Broadcasts are 50 years and typographical arrangements 25. Typographical arrangements are unusual. It's a typeface, it's a particular way a document is structured. It's probably not something you need to necessarily concern yourself about. It's more the content of the work in question that you're looking to protect, and that will be a literary, dramatic, musical or artistic work, which is the LDMA reference at the top. And as I said, copyright is simply there to prevent people from copying in its various ways, shapes and forms. So infringement occurs if, without the authorization of the owner of the copyright, someone goes about copying it, issuing copies, renting or lending copies out, performing copyright works in public, communicating a work to the public, or making an adaptation of the work. That's effectively called creating a derivative work, which is effectively taking a photograph and making a painting from it, or taking a book and making a screenplay from it. That's classified as an adaptation. Copyright is an automatic right. It doesn't require any registration process, which again is why you didn't hear David talk about it last Friday. But it is nevertheless a valuable right, and you should be clear about the fact that you own copyright in something by putting copyright notices on them. Not only does it act as a warning to anyone from the point of view of who's potentially considering an infringement action in respect of that work, it also acts as evidence of the fact that you were the first author, which is a burden of proof that then someone else needs to try and overcome. But equally, if there's a copyright notice attached to a piece of copyright work, it becomes a very difficult task for someone then to say they didn't have the relevant awareness of the fact that the work was a copyright work when they went and copied it, or when they engaged in some criminal activity in relation to it, piracy, for example. So it's an extremely important thing to have on there in the absence of a registration regime. And as you will have seen, it tends to take the form of a copyright symbol, the name of the copyright owner, and the year of first publication after it. Again, websites are another form of very common copyright work, and ideally you'd want the copyright notice above the fold. These used to be, or databases used to be copyright works, but because of the nature of a database and the fact it's constantly updated in many ways if it's a living, breathing animal, it was deemed necessary to create a different right to protect against unlawful extraction and re-utilisation of the contents. Now, databases are collections of independent works that are systematically arranged and made available electronically or otherwise. Again, it's an automatic protection upon the creation of that database, but the big hurdles to overcome are the one of originality, which would be the same hurdle that you need to overcome for copyright in terms of making sure that it attracts copyright protection. But there needs to be a substantial investment at a technical and financial level in obtaining, verifying, or presenting the contents of the database. Protection lasts for 15 years from creation, publication, or substantial update. So this goes back to my point that as a database is a living, breathing animal, it can generate a sort of an evergreening effect in terms of the protection that's afforded to that database over the course of its evolution. And clearly when you're dealing with data, it could conceivably be personal data that you're populating that database with or making accessible in a software format. So you also need to consider the Data Protection Act implications of that and making sure that any utilization or processing of the data that you make available via the database has had the necessary consents obtained beforehand to the uses that you're going to be making of it. Now, this is something that David would have talked about, I presume. I don't know if he talked at length about unregistered design rights. They protect shape and configurations. They only apply to 3D objects. Again, they're automatic in the same way that copyright is automatic. Again, they need to be original, not necessarily new, which is, again, identical to copyright. But you can't get an unregistered design right if it's commonplace in the design field in question. Effectively, it's a 10-year right because it nearly always will be marketed. If a design is of any merit, it will be put into the public domain and applied to an object. And so for the first year, an owner has a period of effective exclusivity in respect of that. They don't have to afford a license in respect of that design to anybody. They have a monopoly right in it to all intents and purposes and can prevent anyone else from copying it. In the last 5 years, someone can claim, well, the owner cannot refuse to grant a license if someone wishes to take a license in respect of that design. Which again, thinking about it, would probably lend you to conclude that the powers that be and the legislators want you to be ever evolving pieces of intellectual property. They don't want it necessarily just to remain static. They want you to be developing and continuing to enhance design and innovation. These sort of things don't attract design right protection. I'm just going to focus on the middle section. These are elements. The first category is a must-match categorization. The second category is a must-fit categorization. So basically, by their very function, or by their very shape, or by their very sort of involvement in a composite piece of technical function, they have to have a particular shape. So there should not be necessarily any design rights that attach to that particular situation. A very similar position, an identical position now, in fact, to what applies in respect of copyright when it comes to ownership. When you've got a design created by anybody, its ownership is clearly that of the initial author at the outset, but in an employment circumstance, it's an identical position to copyright because it vests automatically in the employer, subject to anything to the contrary. When it, up until about 2 or 3 years ago, it used to be that when a design was commissioned, the party that paid the money and commissioned the design was the owner of the resulting design. Now, that was seen to be too inconsistent with the copyright position. These two rights aren't entirely unrelated. So what has happened is that the legislators decided to make it a common position. So it's exactly the same position as copyright now. If someone commissions a design, first ownership will be in the party that's creating the design, and there will need to be an assignment clause in the contract should the party who's commissioned the design to be created want to have ownership. And again, this is entirely something that David would have covered off. The concept of a design that's capable of registration is that it must be new and must have individual character. So it must have a different impression on someone informed in a particular area as against anything that exists in the design field in question. And again, registered designs can be applied to both 2D and 3D objects. So they have great relevance in the fashion industry, in areas of other artistry such as wallpaper, carpet designs, whatever it may be. Furniture designs, for that matter. I don't intend to dwell on this at all. Patents require novelty, they require an inventive step, which is something that is a non-obvious innovation in contrast to the prior art, which is assessed at a global basis, not just at a territory-by-territory basis. And the patent must be capable of a business or industrial application. It must have been kept confidential prior to its filing. Otherwise, it eradicates, it completely removes the ability for it to be patented in the first place. And the ownership position is exactly the same. In an employment context, the owner is the initial inventor, but in the course of an employment, it becomes the employer's. And patent infringement is effectively unauthorized use or unauthorized manufacturing or selling or importing of a patented product or process. Again, David would have dealt with this subject no doubt in quite a lot of depth. For a trademark to be for it to exist, it has to be capable of representation in a graphical sense, and it must be capable of distinguishing one party's goods or services from another. When you come to register a trademark, it is a precondition that it mustn't be descriptive of the goods or services to which it's being applied. So you couldn't create a brand of chairs and entitle the company chair or the brand chair that you're selling those chairs under. You would have to think of something novel or completely off the wall that has no form of descriptive quality with regard to the goods or services that the trademark is being applied to. But there are an awful lot of different classes of goods and services that you need to think about when it comes to registration. And you need to think about which are applicable in the context of what type of business you are presently and conceivably in the near future going to be conducting, utilising that trademark. Registrations can be renewed every 10 years. They can be effectively last in perpetuity, therefore, if you continue to pay the renewal fees on a 10-yearly basis and you don't at any stage cease to use the trademark for an extended period of time. If in fact you do cease to use it for a period of 5 years, it can be invalidated entirely. And clearly, again, I would imagine Dave went over what not to do in relation to making sure you don't infringe trademarks. This position that's set out here is called generating a likelihood of confusion in the eyes of the public. And this position here is called creating a likelihood of association. In essence, what they're trying to prevent you from doing is taking advantage of the goodwill and reputation that attaches to a trademark and taking an unfair advantage of that, in the sense that someone else's business has created a certain amount of reputation, a certain amount of value in the brand, and therefore you shouldn't be able to take advantage of that value unless you have been given a license to be able to do so. Obviously a good idea to do as much searching around as possible, both in terms of trying to set up your company and establish a company name that you want to use going forward, or even just considering a trading name, or obtaining a domain name that's suitable for the purposes of your business, all of which need to be thoroughly ascertained before you go down the route of identifying and selecting the names that you want to work with. Again, when it comes to trademarks, they can be registered or unregistered. When it comes to any unregistered trademark that you're using, you're perfectly at liberty to write TM next to it. You mustn't, however, write an R next to it. That entitlement only comes from registering a trademark. And you clearly want to avoid a criminal conviction for not recognising that particular distinction. And again, they tend to take a similar format to the copyright notice. So you'll see, for example, the main headline brand or the main headline company name is, in this particular case, a registered trademark, and the slogan that attaches to a particular type of product that they release has been kept as a trademark, unregistered. And for similar reasons as you put copyright notices on copyright works, there is no actual requirement to have to do that, but it certainly puts people on notice of your rights and acts as a deterrent to potential infringers, and at the same time generates a presumption of distinctiveness around that particular name or slogan. Domain names aren't intellectual property rights. They're very closely affiliated to trademarks, but they aren't, in fact, an intellectual property right. They are a contractual right to actually utilize the domain name which you are given by the domain name host or domain name provider. Now, all the .co.uk's are hosted or provided by a registry called Nominet, and all the .coms are provided and hosted by a registry called ICANN. But as I've indicated earlier, you can't, particularly when it comes to well-established brands or quite visible domain names that attach to brands, you can't simply look to try and register those with different suffixes or try and generate something materially similar to those types of brands or those types of domain names, because conceivably you could be deemed to be infringing a person's trademarks by doing so. So you do need to be very careful, and again this goes back to my point about making very clear searches at the very outset around the trademark piece, and at a sort of an internet level to make sure that there isn't something out there in respect of identical or similar goods or services in respect of which there's an identical or similar name being used. Okay. If you don't pay heed to that sort of warning, then there is the possibility of you being deemed to have an abusive registration. Theoretically, this is more aimed at people that have gone around trawling available internet domain names to determine what, if any, they can register, and then look to try and extort money from proper users of the trademark or proper owners of the trademark. So in old money terms, it would have been known as cyber squatting, perhaps. It's now classified as abusive registrations, but it's a fine line. You know, your motivation and your motives may be completely clean, but actually the extent of recognition of a particular brand may be such that it can only ever be deemed to be an abusive registration. What you're doing could not be separated out from something that would be presumed to be just another different branch of business from the very well recognized trademark owner. So then, just looking at the .co.uk dispute resolution service that is set up to deal with these sort of things, you'll see that Nominet has been given and has afforded itself a number of powers that it can exercise depending on the circumstances. So, for all the reasons I mentioned earlier regarding trademarks and company names and that sort of thing, you do want to search fairly high and low before you plump upon a trademark. Now, in what order you do all of this, it's you know, there is no particular order. It's all, to my mind, thought about in the same line of thinking and the same thought process. But you do have an awful lot of areas to search in. And please bear in mind as well that a website is inherently going to be a global phenomenon. It's going to be a global thing. So you do have to search the World Intellectual Property Office websites just again to determine a more sort of global feel of the possible use of an identical or similar trademark. Clearly, in relation to any website, you also need to think about the terms and conditions that you need to apply to the use of that website. So that will be, generally speaking, a website terms of use that identifies what reliance and what responsibility you're taking for the content of the website, what reliance can be placed on it by users of the website, what users of the website are and are not entitled to do as they navigate around the website, particularly if there's an ability to upload information or interact with it in some way. But mainly it's a set of disclaimers that you as a website provider are putting in place so that you're not leaving yourself exposed to reliance upon the information on the website, or reliance upon certain links to third-party websites, or reliance on documentation or other things that are referred to in the website, or some formulation of an opinion that in some view is seen to be in some way unlawful. You're effectively just trying to say, insofar as it's just an information-only website, it's effectively a shop window and nothing more than that. We're not committing ourselves to anything else. If it's an e-commerce website, then you'll need to go slightly further, well, quite a lot further, by putting in place some website terms and conditions of supply, some e-commerce terms, which it effectively indicates a lot of things that you would normally see in a set of terms and conditions of supply or sale. It talks about the mechanics of how you go about ordering and how the order is processed and when delivery takes place and the price and a number of other things that you would feel are fairly common. If there is some degree of licensing going on because it's an application or it's a software piece, you'll also have some licensing terms. So that will provide the scope of usage that is permitted, but again it will be underpinned by a lot of usage restrictions and then some securitization of the intellectual property rights owner's position through liability provisions around misuse. Clearly, if the site is taking information from inquiring parties or from users, and that information amounts to personal data, you'll need to think about a privacy policy. And within that privacy policy, you may also need to think about a set of provisions or a separate policy entirely dealing with the cookies that you're actually using to inform a user's experience or the intuitive navigation around a particular website. If a website is heavily interactive, you may also want to take out from the website terms of use all of the use provisions and put them into an acceptable use policy, which again can be a fairly lengthy document dealing with blogs, interactive chat rooms, discussion boards, whatever it may be. Now, confidentiality is absolutely critical, particularly from the point of view of something that you may potentially wish to patent, but equally it can be something just as simple as commercially sensitive information or a form of trade secret. But at a practical level, if you are going to be revealing anything confidential about you or your business, it should only be done on a need-to-know basis. It should only be to not only people but divisions of a business that need to know the information, and the access to that information should be restricted and securitized. So again, it should be only disclosed in a secure fashion, and the obligations that are imposed upon the receiving party need to be as demanding as you would apply to ensuring that your information remains confidential yourself. Keep a contemporaneous record of anything that you do disclose. Make sure that disclosure is staggered and that you only reveal what you need to at any given point of the discussion, which inevitably is going to be pre-contractual, with you trying to figure out whether you're trying to get into a trading relationship or some sort of collaborative arrangement with a third party, a business partner perhaps. Always disclose hard copies if at all possible, because again, it's much easier for you to monitor, much less easily distributable if it's not sent electronically. And make sure you have a contract in place. Make sure all of that is done and all of that is provided for in the contract, which will also serve to define what you consider to be confidential. And you must, within that agreement, make abundantly clear what it is that you're actually allowing it to be disclosed for, and what use and for what purpose the information can be deployed. Because effectively what you're saying is outside the scope of that, it's still remaining confidential. You can't use it for that purpose. That's unauthorized use, and it would be considered a breach of confidence that they would be engaging in. Theoretically, confidential information can be protected indefinitely, so long as it maintains its quality of confidence. As long as it still remains secretive. Coca-Cola's secret recipe, for example. Once it becomes part of the public domain or becomes out of date or of minimal or trivial commercial value, if at all, then it no longer is necessary to protect it as a piece of confidential information. And agreements, generally speaking, need to be restricted to a certain length of time. They can't last in perpetuity, because that doesn't satisfy the requirement for certainty that a binding legal contract needs to have. So have a think about the type of information that you're going to be disclosing, have a think about its evolution, have a think about whether it's going to be superseded and or developed around or enhanced or improved, and then place an appropriate period of time on how long the obligations of confidence attaching to that confidential information need to be stipulated within the contract. Normally it's a 5 to 10 year period. But as well as that, be careful about what you can have different and separate periods attaching to different types of information. There may be some information that you absolutely don't want revealed at all, and it's pivotal to the very nature of your business, or a secret that you maintain and apply within your own business that provides you with competitive edge. Equally, you need to think about employee arrangements. Restrictive covenants in employment contracts can only last for a certain amount of time. So you have to be clear in your mind, and that tends to be about 3 to 6 months, you have to be clear in your mind what the legitimate purpose is that you're trying to impose these covenants for, and make sure that the scope of that covenant, both geographic and in time, and in relation to where that individual is going to be conducting themselves next, is reasonable in the circumstances. But also you need to think about that in the context of anything that you're allowing them to be involved in that's confidential within the context of your business operations. And when it comes to public bodies, you need to be very careful, because they are subject to data subject access requests and freedom of information requests. And if you haven't made it abundantly clear at the point in time that you've engaged in discussions or some sort of dealings with a public body that you consider certain pieces of information to be commercially sensitive or confidential or trade secrets, then they're left to make up their own mind, and they could well, in the course of making up that mind, completely miss the value that you place on certain types of information. So it's important to be very clear about that when dealing with any public body. And yes, it is necessary. It's absolutely and utterly necessary. Whatever views you may hold or that you've been informed about, they preserve the confidentiality required in order to be able to patent. They allow you to freely negotiate the terms of contractual relationship without the fear of your sensitive information being placed in the public domain, and if in the event of some breach of confidence that takes place, then you have a legal right and ability to sue, provided you can evidence that there has been a breach of confidence, and recover compensation as a consequence. So when it comes to intellectual property of any sort, the reason it's afforded a proprietary status is that you then have the ability to commercially exploit it and take advantage of it, in all likelihood, to the exclusion of anybody else. It's a piece of property from which money can be made, and therefore the manner in which you go about doing that can be dealt with solely by yourselves, although that is rare. It tends to need to involve third parties at some stage, and from that involvement and the license that you afford in the process of allowing that involvement, you can generate license fee and royalty revenue. So whenever you're engaging in any discussion of this nature, unless it's you distributing software or an app on a platform of some description, if it's a genuine business-to-business relationship that you're entering into, there needs to be a confidentiality agreement in place, as we've discussed, because there may well need to be discussions that take place around the nature of your relationship and what it's going to involve. The next thing you need to think about is how best to protect your IP and confidential information in the context of that proposed commercial exploitation or trading relationship. And as I said, it tends to take the form of a license that this exploitation will manifest itself. It can theoretically take the form of an assignment, but that's a complete relinquishment of your rights. So the price that attaches to that decision must be significantly higher than the price that you're attaching to the licensing arrangement. So when you're looking at licensing out any intellectual property of your own, you need to make abundantly sure that you're not licensing out more than you need to, and that you're reserving rights in respect of everything that you should retain. You need to think about the nature of the license that you're affording. If you're granting someone an exclusive license, that means only they can use those rights for the period of time and for the purpose that you've afforded them the license. And that's to the exclusion of you. If you grant a sole license, then it's just the two of you that can use that package of rights. And if you grant a non-exclusive license, then that doesn't prohibit you from doing anything other than granting a sole or exclusive license in respect of those rights to anybody else. And what would then feature in your mind is, well, I'm conceding an awful lot then in terms of potential licensing revenue by granting an exclusive license or a sole license. And I need to therefore make sure that that is the right decision that I've made and place minimum royalty or sales obligations on the licensee so that you know your return is being maximized. And if they can't meet that, then the license either falls away or gets downgraded, and you have the ability to move on as a licensor. You need to think as well about how long you want to grant the license for, because it may well be that you'll be tied in and becoming frustrated by it if it's not producing enough for you as a licensor. And you again need to think about whether they are correctly placed to be able to exploit the rights that you've given them in a certain jurisdiction. Rather than just simply saying you can have all of North America and South America, it could just be that they only have the ability physically to properly exploit it in a certain part of that territory. You need to think about as well about whether they need a right to be able to take the license rights that you've given them and sublicense them to other people. If they can't do all that you need of them themselves, they will need to involve third parties in the process. So again, you need to think about whether a sublicense is needed. The problem is, the more you allow that to happen, the less control you have. So it's something that you need to think about carefully, and you may want to put very careful restrictions on how they go about it, possibly even impose the terms at the outset that they have to sublicense. You need to think as well about improvements and who has ownership of those, and whether they in fact do become part of the license going forward. it's a huge area of debate because depending on who invents the particular improvement, if it's the licensor, they may feel that that particular piece of technology is so far advanced or so innovative in contrast to what they've licensed in the first place that they need a brand new license arrangement. But the licensee will probably argue that they want it encapsulated into the previous licensing arrangements, and it will just simply have an impact on the license fees or the royalties. Equally, if a licensee has generated an improvement because they've seen how a particular piece of technology can be developed in a certain way or developed further or adapted to something entirely different, they may argue that this is brand new and that rights in it should not vest back in the licensor. Having said that, they wouldn't have had the ability to do it without the original IP in the first place. So it's a big discussion, but it's one that should be itemised within the relevant agreement as to where things stand. And as a licensor, I would be very, very reluctant to relinquish any ownership. Clearly, you need quality controls around products in which IP rights are incorporated, otherwise that damages the IP rights and their value, perceived value. Clearly, you're in it for the money, so you need to determine what form and what structure license fees and royalties take, and how those are calculated, and at what level, and whether they're decreasing or increasing, depending on the passage of time. You need to think as well from a licensee's perspective that you're sort of placing yourselves at the mercy and in the hands of a licensor, and the fact that that licensor has gone about creating intellectual property in the correct way, and is not, by doing so, infringing some third party's rights that is then going to come back and bite you as a licensee if you try and exploit them. So you will want to seek, the licensor will want to seek warranties from the licensee that they won't do things outside the scope of the license and they won't damage the intellectual property in any way. The licensee will want to have warranties in place from the licensor indicating that the IP is original, it doesn't infringe as far as they know, and they're capable of granting the rights that are being granted to the licensee. And then obviously you need to think about what would cause it all to come crashing down, and what gives rise to a termination event in the context of the license itself. Because again, it can't just continue to last in perpetuity. It has to have some finishing point, and whether that's just a preset term, or it will inevitably be some sort of preset term, but it will also be the right to terminate earlier for a breach of the license or a challenge to the validity of the IP in question or something of that nature. And then when you're looking to license in IP, because you may not necessarily have all you need to conduct your business, and it could be ready-made in the hands of a third party, you obviously need to look at the position very differently. You will be the licensee in that situation. The licensor will be thinking about things from the perspective that I've just informed you about. They will be looking to protect their interests, making sure the IP remains valid, making sure your usage of it is not going to impact upon it adversely in any way. So you need to put a different hat on and a different perspective when you come to consider the terms that are being imposed on your licensing out of anything. And when you're dealing with the creation of IP and collaborations, it's a hugely vexed area. People would be well advised to document it at the outset as to where ownership of intellectual property lies when it comes to some sort of collaboration that's going to be ultimately generating some brand new intellectual property. Clearly both parties will be bringing something to the piece, so that will be a clear ownership position and possibly a cross-licensing position to allow each party to use the other's IP in terms of generating some new research or new outcome. But then the new foreground IP that results from that, who owns that? And that's the real question here. You can't just simply say it's jointly owned, because in most cases that therefore means each party can individually use it for their own purposes. But as soon as you try and license it to a third party, the other party can veto it. So you could just stagnate. It could just become a fruitless and hopeless exercise. So you need to have a position agreed in advance, other than a joint ownership position, where one party owns it and the other is licensed as needed to be able to use it. And you're going to have to get, between you're going to have to get your head around it. Who's got the greater need for it? Whose IP has been most relied upon, or effectively has been the greatest amount of bedrock for the new IP that's been generated? And actually, all it really amounts to is, from your point of view, an ability to utilise it for the purposes of your business going forward, for so long as it's relevant IP. So actually, a license is not necessarily a bad one, a bad position to be in, particularly if it's a sole license, for example, because it's then only the two of you, that are entitled to use it. And you know, again, that could be for a considerable amount of time, which gives you the competitive edge and advantage you need to, and the certainty you need to conduct business going forward. And innovate around it in your own case as you become more advanced as a business. So that needs to be thought about quite a lot. It's a really big issue. And the very last thing you want to do is just relax into a joint ownership position without giving adequate thought to it, and then finding out that you're prevented from doing something by your fellow joint owner further down the line. So, look to avoid joint ownership if possible. Decide it in advance, who owns it, who needs the rights to use it, make sure the license is appropriate. Okay? Segueing nicely into commercial contracts, which, you know, an intellectual property license of any description is a form of commercial contract. Now, a contract, I apologise if any of your lawyers, you've probably seen this already in sort of the early days of your degree, but there are 4 ingredients for any contract, legally binding contract, to come into being. Offer, acceptance, consideration for the obligations that are being asked of you, and an intention to create legal relations. So you should always be aware of these 4 factors, because actually if all of these 4 factors are evidenced at any stage of a relationship between 2 parties, there will be a binding contract in place, which you may or may not recognise or want or know that you're involved in. So be very careful. For an offer to amount to the kind of offer that's required as an ingredient for a contract, it must be a promise by one party clearly to enter into a contract on a certain set of terms, and those terms must be specific, they must be complete, capable of acceptance, and made with the intention of being bound by the acceptance. So an offer can be reasonably simplistic. Again, this goes back to my point about making sure you understand what an offer amounts to, and that you're not inadvertently getting into a contract. Because even if it is basic, and even if it is simplistic, and if there's no further intention to add any further terms and no further bargaining to be carried out, it could amount to an offer that can be accepted. But a person who's in the position of making an offer is able to retract that up until the point in time it is accepted. So it can pass by a lapse of time, it can pass by withdrawal by the offeree, or offeror, a rejection by the offeree of the offer, they're not happy with the terms, or a failure of a condition precedent, and we'll come on to what that amounts to in a minute. Just looking at a sort of everyday principle, and it's something that applies online and offline. The position that a supplier should always aim for is that they are effectively operating a shop window, whether it's a website shop window or a physical shop window. That's what's classed as an invitation to treat. It may well have prices on it, it may well not, but you're offering goods or services for sale, and that's called an invitation to treat. It can similarly amount to a quotation. What then happens is, if a party wants to take someone up on that, they will then make an offer to buy those goods or services for the quoted price. That is an offer. That's not an acceptance. Okay? So you've got the invitation to treat, you've got the offer, and then finally, as the supplier, you have the ability or not to accept that offer. Okay? So it's a 3-stage process. It's not a 2-stage process. And actually, a supplier should never ever get themselves in the position where they are actually found to be making an offer, and the consumer or a customer cuts them off immediately and accepts. It should always be the customer that's making the offer, and it should always therefore be the supplier that's electing whether or not to accept. Okay? That applies equally online. So again, never use any phraseology in any sets of terms that indicate that what you're doing by operating a website and putting prices on it or making information available about the products or services on it amounts to an offer. It doesn't. Okay? It's just an advertisement, it may even be a quotation. And you need to reserve the rights to be able to accept, or not, someone wanting to buy a good or service that you're advertising for the price that you may or may not have said. You still want to reserve that ability to say yes or no to that. You may not be able to do it for whatever reason. Lack of availability, lack of stock, lack of suppliers, force majeure, whatever. So you have to be able to make an assessment at any given time as to whether you can meet that demand. Okay? Acceptance is a final unqualified assent to an offer. It's not, I like most of that, but I'd like to change that. That's a counter-offer. Okay? So again, be very clear about that, because that then allows someone to accept, which you may not want. Okay? So be very careful about whether you want to make a counter-offer. Be very clear that it is a counter-offer, not an acceptance. But equally, by making the counter-offer, you have to realize that that in itself could be accepted. Okay? Must be communicated in some effective manner. Normally in writing it's communicated. But equally, contracts can be entered into in a verbal way. And you can get yourself in a position, and again this goes back to not necessarily knowing that you're getting into a contract, but if you generate what's called course of conduct, where the parties understand just through how they've conducted themselves without a contract in existence, that certain terms apply, certain payment terms are accepted, certain delivery timescales will be met, the goods will satisfy certain criteria. You're pretty close to a consensual arrangement that is mutually understood, that both parties have an identical understanding of, and your money's passing forth and the parties have an intention to be legally bound by it. So again, be very careful. Consideration is value or something of worth, so it doesn't necessarily need to be monetary, it can be something in kind. But it's effectively what someone is receiving for the performance of a set of obligations. It doesn't, whatever you consider to be an adequate level of consideration is largely irrelevant. If the two parties have negotiated a contract and between them have derived in the circumstances a value that attaches to something, who's to say if it's a peppercorn rent or not, or it's a nominal consideration of £1 or £3 million for the IP license that you're granting them. It's just whatever the parties within the circumstances deem to be applicable, and it must move from the party who's promised to receive certain things. So, from the customer, from the buyer. This is, it's not as high-minded as it sounds. It's more a sort of contextualized perception of what is going on. In a business-to-business circumstance, it's a presumption that exists. It will always, in terms of any interaction between businesses, be deemed to be a situation in which the parties intend to create legal relations. Even in a consumer context, again, you're dealing in retail, you're dealing in commerce. Again, the intention is there. At a personal level, that it may become slightly more debatable. But generally speaking, if the parties are consensual, and if there is a circumstance in which a set of obligations are owed and something has been received in return, that to my mind generates a situation where there's an intention to create a contract, and it may well have already been created by a course of conduct already. And as I said, they can take verbal form as well as written, so be very careful again about what you're verbally committing to. I would always suggest that all discussions that you have are actually subject to contract or without prejudice, and that everything ultimately gets mapped in writing for certainty, for evidential reasons, should there be a debate. Because actually, at a verbal level, before you've bottomed out everything, and remember that an English law-governed contract has got to be entirely prescriptive, it is going to be classed as the entire agreement between the parties, to the exclusion of everything else. So actually, at a verbal level, can you hand on heart say that you're in complete agreement across all potential terms that need to be included in that arrangement? Probably not. There could well be some discrepancy. Okay? Actually, in certain circumstances, for example, when a deed is required, where someone's guaranteeing someone's obligations, where someone is, in many cases, assigning a piece of intellectual property with or without consideration, there are certain circumstances where some of this needs to be done in writing. That's a legal position. It just has to be done that way. But your advisor, should you use an advisor, will be able to tell you.
How can you enforce that?
Enforce? Well, it's a much bigger evidential burden than if you have a written contract and a set of terms, and you can clearly see that something has not been complied with, which very clearly then amounts to a breach of contract. what you need to prove if it's a verbal arrangement is that these terms were mutually understood to be the basis for the relationship, and that one of those has been breached. So you've got a two-step process in many ways, whereas the first one is an automatic given because you've signed a written contract. These are documents that precede, generally alongside a confidentiality agreement, they precede a fully fledged contract. And they have a number of different names, as you can see from the top. They all mean exactly the same thing. But they allow, and their major purpose is to allow both parties to see how close each other is to a deal. In other words, a general level of consensus about how they're going to conduct business together or interact together or have a relationship at a business level. So it serves as a framework for effectively putting in place a fully fledged contract. So before you've been able to isolate key terms and decide if you're actually close enough to formulate a deal and go down the route of trying to get into a contract, it might be advisable to determine whether both parties have a common understanding of what the key terms are. And that's the purpose of one of these documents. But getting into them obviously generates a form of moral commitment almost to, once you have agreed that these are the common principles that we want to conduct business on, you can't just then expect to generate an agreement that's fundamentally different in key respects. You know, there is this understanding that there will be some level of consistency. The law are non-binding, they're automatically non-binding, so you can't be held to them, particularly despite the moral obligation to comply with them, remain consistent with them. But there are elements of them, or you have the alternative, in fact, of making them binding. But if in order to do that, you would need to indicate very specifically in the document that all or part of that document is considered to be binding. Now, in most heads of agreement, for example, you'll have confidentiality provisions. You may well have exclusivity of negotiation restrictions. You'll have provisions around governing law that apply should there be some sort of dispute about the heads of terms themselves. So some of these will need to be binding terms, even though the overall heads of terms themselves are, generally speaking, non-binding. But as I said, if you go back to the purpose of what these are about, they are beginning to generate a legal framework, but they're just trying to figure out if the parties have a common understanding of the key terms upon which they want to engage and do business. And that's, again, another variation. The thing with that variation is it also maps out a timetable over which the parties are going to be looking to, effectively conclude negotiations, agree a contract, and possibly even engage in the beginning of performance of the goods or services. Now, I mentioned this concept earlier. Again, it exists to allow parties to get into a contract, but on a basis and an understanding that if a certain condition is not met, that the contract falls away. So, for whatever reason, you don't have time to wait, so you get into the position where you are contractually bound, but clearly the parties cast their mind forward to a particular instance whereby, or a particular matter can't be satisfied before the parties enter the agreement. So, it's a conditional contract in many ways. And in effect, a binding contract, in its complete sense, doesn't exist until that condition precedent is satisfied. Now, there can be any number of different forms and types and reasons for a condition precedent, depending upon the nature of the parties or the field in which they're operating or the type of business that's being conducted, or the funding of the arrangements themselves. Clearly, if you've got condition precedents, you also have conditions subsequent. A classic example would be the one at the bottom in many ways. Party A paying an allowance to Party B until Party B marries. So, in many ways, it almost generates a position where it's one of the reasons that an agreement will terminate. It may or may not ever be satisfied, but its occurrence will immediately cause the arrangement in question to fall away. I don't know if you've come across this phrase before. There are different variations. There's the use of reasonable endeavours, there's the use of all reasonable endeavours, there's the use of best endeavours. All of these are not absolute obligations. you must, you will, you shall. That they are absolute obligations, so they have to be done. These are, we will use reasonable endeavours, or we will use our best endeavours to achieve that particular requirement, but if it doesn't happen and we have used those endeavours, we are not in breach of the contract. So the common wisdom is that best is the highest of these types of non-obligation commitments. All reasonable sort of hovers somewhere in the middle, and reasonable is at the bottom. Reasonable, it would suggest, in terms of case law, is doing everything you can other than effectively committing yourself financially to try and generate the required outcome. Best, on the other hand, is it's absolutely clear that that does and can and should involve some degree of financial commitment to make sure that the obligation is met. And all reasonable hovers somewhere in the middle. So I would always suggest be very careful of best, because best is pretty much trying everything you possibly can, although you may not get there. And that includes a degree of finance, quite significant perhaps, financial commitment. When it comes to goods, this is the piece of legislation that serves to imply terms into contracts governing the supply of those goods. Only one of these is unexcludable. It is an absolute given that it must apply in every situation where someone is selling goods. And it's the very first one. So you can never, in any document, look to try and exclude the fact that whatever you sell, you are providing those goods to a third party without any charge or any third party interest in those goods. In other words, they're free to be owned by the party to whom you're selling, and that you're able to give ownership, full ownership, to the party that once they pay you the money in return for the goods. Okay, so none of that can ever be excluded. All of the rest can be excluded in contracts, but if you're dealing with businesses, it's deemed to be slightly more reasonable, depending on, again, the nature of the relationship. If you're dealing with consumers, it's probably unreasonable to be excluding a lot of these. What you need to do in relation to consumer relationships is very, very different to businesses, because the automatic presumption is that businesses operate at a far higher level of bargaining power and have far greater contractual influence than a consumer, and a consumer needs to be protected accordingly. So goods, if a contract is completely quiet, all of these terms will be implied. Goods must conform with their description or with sample if that's been provided prior to that. They must be of satisfactory quality and they must be fit for purpose. Normally in business agreements you tend to agree a specification for a set of goods, and that will be the thing that you warrant, and you will exclude all of the other warranties. But in effect the buyer's happy enough with that, because it's ensuring that in the process of agreeing the specification between the two parties that they've got to a position where, so long as that is met, that they're happy with the goods in question. If a contract is quiet on price, the price must be a reasonable one. If it's quiet on the time for payment, cash on delivery is the required payment mechanism. And if they're quiet on where goods need to be delivered, it's the fact that goods will take place, or delivery of goods will take place, at the seller's place of business. So again, all the more reason, if those are not things that you're comfortable with, or they're insufficiently clear or slightly vague, you've got to cover it off in the contract, specifically. When it comes to services, the main term that's implied in any services agreement, and it's highly unlikely for you to be able to exclude that, although you can try to. Again, if you're marrying a service provision up to a specific services specification, then you can probably get away with it, but I wouldn't suggest otherwise. The standard of performance of the service in question must be carried out with reasonable skill and care. If again the contract is quiet on time of performance or on price, it has to be a reasonable time for performance and a reasonable price in any given case. But again, specificity and clarity is by far the better option, so all of those things should be addressed within the contract. When it comes to goods, clearly the seller of the goods is going to want to retain title in those goods until such time as it receives full payment for those goods. So basically what it's saying is, when it comes to these kinds of provisions, you're placing yourself in a position as a supplier whereby if something untoward happens, the customer at a financial level, you're trying to place yourself in the best position possible to either receive the money that you were owed or recover the goods entirely. The references at the bottom there to an all money clause, these are sort of contractual mechanisms that you look to try and put in place as a supplier to protect your position. An all monies clause is a clause that says we may have made a number of supplies to you over a number of different sets of goods, but actually none of those goods in terms of ownership will pass to you until you've paid all the sums that are owed. Okay? So it doesn't just pass on a contract by contract basis, it's dependent on everything being paid for. A proceeds of sale clause is fine, you may not have paid for these, but actually if you resell them, either by themselves or as part of something else, you will hold the proceeds of sale to the extent it marries up to what you owe us on trust for us, and then want to count back to us for those proceeds of sale. Okay? And a mixed goods clause is, again, back in this position where something is incorporated into something else. This is slightly harder to argue and slightly harder to sustain as an argument, but it means effectively that if something hasn't been paid for and it's put into something as a component part, then property in that entirety of what it's been combined into becomes the supplier's. Now, you can see why that generates a more difficult argument to sustain, because it could well be that that's a phenomenally more valuable piece of kit than the component part or the item that was supplied. But you know, there are variations between the two, and you can try and make it more reasonable by working back from that position. And then, as I said, retention of title is not just about protecting your interests and making sure you're trying incentivizing payment. It's also to try and preserve the position of physically getting your hands back on the goods if you're not able to receive payment. So you need to think about rights to walk into the buyer's premises and reclaim possession, separate storage rights, making sure that the goods themselves aren't mixed up with other goods, making sure that they're marked clearly, and that within the contract itself, if there's any inkling of anything of an insolvency nature or a cessation of business or something by way of financial straits happening, you have the ability to call everything back in again. The thing with risk and title, risk is effectively responsibility for the goods and any loss or damage that occurs to them. So when that passes, it can vary. It can pass at the point in time it leaves the supplier's premises, or it can only be taken on at the point in time it's received by the buyer. You'll see what the standard position tends to be there. As far as the seller is concerned, it's clearly to try and pass risk to the buyer as soon as possible. So, and this is risk in transit, risk in the process of carriage. So you'll have to pay for insurance and that sort of thing from the point in time it leaves the supplier's premises. Clearly, from the buyer's point of view, they want to make sure it's the supplier who's footing the bill for that sort of thing. And title, as you will have gathered, is something that, from a supplier's point of view, will only really pass whenever they get paid in full. Ultimately, there may be certain circumstances where the buyer can insist on title passing on delivery. At that point, that's fine, because there's still this contractual obligation to make payment. But clearly, from a supplier's point of view, they would then not have the ability to go and reclaim the goods, because they would have sacrificed possession. Whenever this phrase is used, it's effectively stating that any failure to meet a particular timescale is going to result in an ability for the party to terminate the agreement and claim compensation. So it's a significant statement to make in any respect, and should not be used lightly and resisted if at all possible. If you're partially or partly going to be susceptible to anything that could cause time to be missed by way of the performance of an obligation, remove the phrase entirely. There may be certain circumstances in which, time is of the essence is a legal position. It's covered under contract law and common law generally. There may be certain circumstances in which you can employ the principles of equity to protect your position as someone who's needing something to be performed at a certain time. And these are things like making flight bookings, or making bookings of hotel arrangements, or the hosting of an event on a particular day. These are so time sensitive that there can't be anything other than the performance of the event at that particular time. There just isn't any more room for manoeuvre. So in certain circumstances, a time of the essence position has to be implicit and will be inherent, and equity will protect that, whether it's through injunction or something called specific performance, which is that something must actually be carried out. It can't not be because of the event itself. This is key, from both parties' point of view, and it is always a sort of a regularly sort of discussed and argued position. Suppliers will always want to try and limit liability or exclude liability as much as possible, but they can only do so long as it's reasonable and therefore enforceable. If you're dealing with a business-to-business arrangement, clearly you can negotiate a position that both parties feel comfortable with, and both parties are usually deemed to have an equivalent bargaining position. If you're in the position where you're entering into consumer contracts as a business, you need to be much more careful with your statements about what you're willing to assume liability for or not. So that's certainly something to bear in mind. Certain types of liability can't in any way, under any circumstances, be excluded. So any attempt whatsoever to do that in any context, whether it's business to business or business to consumer, will fail miserably. And the concept of that is that actually what you've tried to do in all respects with regards to limiting liability or excluding liability falls away, and you ended up, by what you were trying to do and overstepping the mark, you end up in a position where you are completely exposed to all liabilities. So my advice would be to think about it carefully and make sure you're being reasonable. So all of these cannot be excluded. The reference to defective products is defective products for the purposes of the Consumer Protection Act. You can't limit liability under that particular piece of legislation. And good title, quiet possession, and no encumbrances, that goes back to that implied term I was talking about, where you can't sell something without being able to provide all of that. So what you can exclude liability for are those sorts of things there. But again, you can only do so to the extent that what you're trying to do in respect of those exclusions and limitations is reasonable. And for it to be reasonable, it must satisfy that test. And that's really an objective perspective that's being applied there. It's not a subjective test. Clearly going to court is costly. And it's uncertain. I mean, despite how strong your case may be, or how strong you feel it may be, it may get protracted, it may become extremely costly, and the damages could be of a scale that you hadn't anticipated. So there's an awful lot of just cause in trying to include something within a contract that effectively tries to pre-estimate the position. And you'll find, therefore, that liquidated damages tend to try and be used as a mechanism for doing that, where the parties pre-agree what, in certain circumstances, will be the likely loss that they will suffer, and therefore the compensation that gets paid out, rather than placing yourself at the mercy of the courts. What you can't do in that context, however, is over-egg the pudding, because that then becomes an unenforceable penalty. So in order for one of those types of provisions to be enforceable, it must be a genuine pre-estimate of the loss. So the previous test around that area was, if it's not a genuine pre-estimate loss, it will be an unenforceable penalty. In other words, if there's a clause that's simply intended to punish non-compliance, and it therefore allows a claimant to recover money for the breaches by the other party that are not linked, or have a limited connection, or disproportionate to the loss suffered, then you're in the realms of a penalty. The test nowadays, and very recent case law, is that in order for a clause not to be a penalty, it must be there to protect a legitimate interest, which you must be very clearly able to evidence. It must show the other party performs the contract rather than penalising them for not performing. And it must provide remedies that are proportionate to the legitimate interest in question. So, a change of emphasis. Okay. And obviously, everyone is very happy to get into a contract and full of the joys of life at the very outset, but the fact of the matter is it will come to a conclusion at some stage. And you need to be very clear about the mechanisms around how it can happen, whether it's just simply going to be a position where it has a certain term and it can only be terminated for cause during that term, or whether there's actually an ability to terminate at any point over the course of that term, and if so, what happens in that respect. clearly trying to suggest that you are allowed to terminate an agreement because you have breached the contract is something that's highly unusual and wouldn't necessarily cut mustard. So these are the different types of termination clause that you'll expect to see. The termination on notice clause is largely what it says in the tin. It can have a sort of an open-ended sense of operation, or it can only be allowed to operate after a certain period of time. So you can guarantee yourself a minimum period under a contract by saying termination on notice can't take place until such time as a period of 1, 2, 3 years has elapsed. And you know, you think about that in the context of what you need as a provider or as a supplier to recover your costs and make a certain level of profit. Termination on breach can take place at any time. It's one of the causes of earlier termination if you've set a term. But again, from the point of view of making sure that it's not used disproportionately, you want to probably provide a remedy period. Because things happen, things are missed. Idiosyncrasies happen in the course of producing products. Payment delays happen for any number of reasons. So again, you wouldn't want one of these delays or one of these hiccups to jeopardize the position. Clearly, if someone becomes insolvent or ceases to trade, the ability of the agreement to actually stand up and continue finishes almost immediately, so you want an immediate right of termination there. And you also maybe want to think about whether a change of control of the other party, particularly if it's to a competitor of yours, could trigger termination in its own right. Last thing you want is to do business with a competitor, obviously. And equally, it's all well and good thinking about termination, but then how do you unravel the position? How do you get yourself out of the arrangement you're in? How do you give back all of the confidential information, all of the stock of goods that you hold now that you're not able to sell on? Handing back of data, handing back of information, customer records, whatever it may be. Whatever it may be, you need to think about practically how you get yourselves back in the same position you were in prior to the arrangement starting, or how in fact you need to assist in the handover to somebody else. This is a position, it's a common law position, but it's very valuable to include it in a contract and explain exactly what you're thinking about in the context of a particular agreement. Effectively, it states that if there's a position whereby for events or circumstances outside of your reasonable control, you are not able to perform an obligation, you can't be held liable for that. And that's a fair position. You know, if there's something that takes place that prohibits your performance or your supply of something or your payment of something, and it's not been something that you've had any input in, any involvement in, anything that you could have done anything about, the common law position is fair. It's that neither party should be held liable for that. So it's important to effectively state that that is in the party's understanding and that that forms part of the agreement in any given instance. And it's also important to then maybe provide examples as to what you think would be within the nature of that relationship, something that would be considered not to be within the control of either of the parties. And then when it comes to trying to make sure that a contract has the ability to survive and stand the test of time, it really is dispute resolution is about making sure that the parties can have an amicable way of finding a resolution to a problem. So it's all about escalation. You know, first, if any dispute arises, it's discussed between the contract managers. It's then escalated to the managing directors. It then maybe even goes to an alternative dispute resolution body so they can mediate over it. Obviously, all the while trying to avoid litigation, which again is uncertain and costly. And that's an example clause there of the tiers of escalation you can look to go through. And clearly you need to decide what governs in terms of the governing law of a contract, what the legal principles are and therefore that apply to the contract, and where any particular dispute, if it can't be resolved, needs to go in terms of deciding it. All of what I've said is about what needs to be in terms. Actually, the most important thing is actually making sure your terms govern the relationship. Now, in any business, it's essential to have a set of standard trading terms because they will be specific to your business. They will recognize the idiosyncrasies of your business. They will understand your supply chain stresses and strains. They will understand the cost and time involved in creating the product or supplying the service. As you can tell, there isn't one size that fits all in relation to a set of terms and conditions. They need to be sculpted and fitted to your business and the nature of it. And for that reason, whenever you come to enter a relationship where you're engaging in that business, you're engaging in that supply, you would want those terms to be the basis upon which you do that. So it's important that you incorporate them properly, and it's important that you, but by that I mean whenever you make a quotation, whenever you indicate you receive any degree of interest in what it is you're providing by way of goods or services, you make it abundantly clear that this is the position and these are the terms that will apply to any such supply. And actually any quotation you give is subject to those terms applying. It's too late to try and impose these terms after the contract's been performed and you've invoiced it. Because actually, as I've just said, the contract has been performed. So at that stage you're in a position where, is it a course of conduct? What terms actually applied? Did they have some set of purchase terms that they attempted to try and incorporate? You could find out you're subject to some purchase terms. Hugely purchaser favourable, very supplier unfavourable. It's the last position you want to be in. Whether it comes to payment, whether it comes to the assumption of risk, whether it comes to the obligations and responsibilities that you've got to assume in the context of providing goods or services, could be hugely disparate to what it is you're comfortable with and the nature of the business. So get it in front of the customer early as you possibly can, and as regularly as you possibly can, to make sure they're in complete understanding of the fact that it's your terms that apply, and make it abundantly clear as well that if they attempt to try and impose any of their terms, that's just not going to wash. It's not going to happen. They don't apply to this relationship. Ultimately, though, so here are a number of ways that you can, again, try to make an indelible imprint in the customer to make sure that they understand the position. But ultimately, it could just result in a back and forth. You attempt at the very outset to impose your supplier terms. They come back saying, yeah, we're happy with that, but we're going to impose our purchaser terms. You've got to be very careful to respond to that. In other words, you have to respond to that, re-emphasizing again that it's your supplier terms that apply. Because if it's left quiet on the point, the last shot that's fired in that battle wins the argument. Okay? Does everyone understand that? That's key. So don't just think I've done it once, that's more than enough now. It says within my terms that my terms apply. In fact, what they've done by issuing what is effectively a counter-offer is suggest that their terms apply. So they've not in fact accepted, despite the fact that they may have accepted the quotation, they've not accepted the terms. So it's a counter-offer, and if you simply relax into performing the contract, providing the goods, providing the services, invoicing, by conduct you will almost inevitably be deemed to have acquiesced to their terms. Okay, so be very careful. This is something that should be dealt with in the contract itself. At a common law position, if you're going to vary any agreement, it has to be done in writing. It has to be effectively another further agreement that's entered into by the parties. So it pretty much follows the same lines of formality. It effectively needs to be very clear that the parties have reached consensus on a change to the document. Okay, so bear that in mind, and it will nearly always, as I said, be dealt with in the context of the agreement anyway. So just follow the particular provision when it comes to that sort of thing. Okay. Clearly don't engage in bribery. This is a brand new piece of legislation, been up and running now for 2 or 3 years. Try and avoid any of that when it comes to trying to engage in business. Okay. And this is brand new, literally brand new. So you now have a whole new consumer rights regime that you need to recognise and get your head around when you're dealing with consumers. Blacklisted terms, largely speaking, effectively amount to things that are just immediately unenforceable, such as the types of excludable liability, non-excludable liability, sorry, if you attempt to try and exclude liability for those sort of things. And then there are the grey listed terms, which are areas that are slightly risky, and you therefore need to illustrate that you're satisfying the fairness test. So again, it's the need for fair and open dealing. It's that the terms that you're employing are transparent and easily understandable, and that you're not looking to skew the risk and responsibility unnecessarily and unfairly towards your favour as a supplier, to the detriment of the consumer's interests, who again is placed in this position where they are deemed to be a susceptible person or a susceptible entity. And new remedies for defective goods. There's effectively a 30-day period now for parties to reject, customers to reject goods that don't match up to the implied terms, and you will have recognized the implied terms from that slide I showed you when it comes to the sale of goods. All of those things apply to a situation where you're selling to consumers. So they have the ability to effectively send anything back within 30 days that doesn't meet those implied terms. If they don't, they still have the ability to require a repair or replacement. If it turns out they don't match the implied terms, and actually if that repair and replacement is then faulty, they also have the ability then at that stage to ask for a price reduction, which could well be 100%, if they actually exercise the other right that's allowed of them, and it's a final rejection. Okay? When it comes to services, equally, again, you're in the realms of the reperformance of the services or a price reduction. And again, that price reduction can ultimately be nothing if the whole service provision fails. Okay? Aside from that, it's easy. Okay?
Thank you, mate. So, obviously in there is a massive amount of information. And I think the reality is, you do need to consider, you need to understand this. A solid legal structure will save you so many problems down the road. And you can ignore this stuff, but it's the law. And there's no way around it. So to engage with that, and this is why at the end of legal documents you have so much information. So you need to engage with this, you need to understand this. And this will also help you understand your business better. It will help you understand the compliance of your business, how it works, how it trades. And when you do run into into issues, it will help you resolve things better because you've been far clearer at the start with how you are setting out how you are trading. So a massive amount of information there. I'm sure that's blown your mind, but you need to know these things, okay? So, I want questions now, please. Questions?
I'm here 2 Wednesdays a month now.
You are. So
if you have any questions.
At least 2 questions, please. While you're thinking of questions, Ed is available 2 weekends. 2 weekends? You're available weekends now. There you go. 2 surgeries a month, but that is only available to venture members. So if you're in the lab, you're registered in the lab, and you're working on a business, it's not available to anybody else. And he is there to help and provide information for you. Okay? Questions? Rain, have you got a question? I bet you have. You're going to have 100 questions afterwards. I'm sure you've got one now.
I got questions, but I let anyone else answer.
No, you will go first, and maybe second and third.
Okay. I wanted to talk specifically about the, you didn't mention the deed of assignment of the IP rights, that document. Is that necessary? Because based on what you said earlier,
it's not necessary. It's not a necessary document, except until you want to actually relinquish entirely your ownership of some intellectual property for some reason, whether in the context of a business sale or just to allow someone else to take advantage of it, and for you to be reimbursed, sort of heavily reimbursed for the value, not only at the time of that intellectual property, but conceivably going forward.
So this is I take on someone external. So what if it's someone internal? So I could take on people to do the design or something like that.
Yeah, so assignments, as I said, in the context of whenever you've commissioned someone to do a piece of work, you will need to get an assignment of the intellectual property rights and what they create in order for you to own that. Otherwise it will remain with them. And there'll be a headache around to what extent you're actually licensed to use what you've paid for. Now that assignment will be formulated within another document, whether it's a consultancy agreement or a website development agreement or a software development agreement or a contract for the provision of services, whatever it may be. So it will have its written form. But actually, if you're just taking a piece of intellectual property and assigning it to somebody, whatever the context may be, just as a self-standing entity or a self-standing transaction, to allow them to then take that intellectual property and utilize it going forward, or to effectively perfect a situation where it hasn't been properly documented in the first place. That's what I mean. That will need what's known as a deed of assignment. Because actually, let's take the last example. You'll have paid all your money for the services in question that were provided at the time they were provided. So you don't want to pay anything further again. And actually, going back to that contract slide, you need consideration still, except when you execute something as a deed. Okay? If it's executing something as a deed rather than just simply a contract or an agreement, you don't need consideration. So it just needs that written form at that certain time for that particular transaction to be legally binding.
Keith?
Yeah, in my case, I'll probably be having some sort of contract in the States.
Okay.
Now, about actually sorting out some sort of contract, and also probably an NDR as well, or NDA for him.
Yeah.
How would that work if I'm not actually, say, living in the States, say I'm living in here, but
Yes.
I'm actually doing a contract out there? And particularly because America, I would think with the different states may have different rules as well.
Every state has its different laws, and it also has federal law on top of that.
Exactly, yeah.
So if I were you, from your point of view, I would insist on, are you supplying services, or are you, okay, so I would insist on your supply of those services being conducted pursuant to English law applying. You're perfectly at liberty, the parties are perfectly at liberty to choose what law governs the arrangement. You don't have to simply concede to having it governed by Delaware law or whatever law applies to the company you're dealing with. You know, I don't know if you're dealing with a company, it will be incorporated in a particular state and it may well therefore prefer to be subject to its laws. But from your point of view, so that you know what's required of you, and there's an easy argument around this, which is that English law is a common law situation. It's not referable to a constitution or some sort of civil code, some sort of centralised document. So everything that governs the parties' relationship is included within that agreement, and there's an entire agreement clause at the back of that agreement to say that. So it's very clear.
Yeah, because America's very different in that sense,
Yeah.
isn't it? Yeah. Okay, that's
Ed, in the scenario that you're selling software through one of the established app stores,
Yes.
Can you just comment in general terms about how much control you have over terms and conditions in that kind of situation, and how much legal work you would anticipate needing to do to get up and running?
The agreements for the utilisation of the tools to get the apps onto the platform are set in stone. They will be provided by the relevant platform provider. At the point in time you're then making apps available, I think you're at liberty to impose whatever terms you wish. I don't know what degree of oversight or constraint is applied by the platform provider. But I mean, you know, that's essentially your business at that stage, so you should have the entitlement to have control over that. And equally, in an IP sense, that's deemed to be yours as well, despite the fact it falls under the umbrella of this overall platform. So I think you probably just have just as much work doing what you're doing in terms of setting yourself up as a business and having the right trading terms and licensing terms. But you do need to be cognizant and observant of the terms that apply to the tools that are being used and the overall platform.
Sasha?
So, if I'm saying to someone, I'm selling you this for £10, that's an offer below it. I speak hypothetically. I'm saying, if I were to offer you £10, would you accept that in an offer or an invitation to treat? Speaking hypothetically.
I think that's an invitation to treat, isn't it? Because if I were to offer you £10, then allows the conversation to flow along the lines of, okay, I'd like to take your £10, at which point you can then decide, I can or I cannot give you £10.
So basically speaking hypothetically gives you more protection because
Yeah.
it's a three-way process rather than a two-way.
Yeah, you're allowed to reserve judgment. I mean, actually, you walk into any shop, take something from the counter, from one of the aisles, and place it on the till. That's an offer. You would think you're actually accepting that, a product at that stage and going to pay for it. That's still an offer, and they can say, no, I'm not. I don't care if that's the price. I can charge you £10 for that now. At which point you can then choose to go away. Because you actually thought you were making an offer on a certain basis, and they're turning around and actually placing a counter offer on you, and then you're in the position of whether you accept or not.
Did you have a question? No. Anyone else?
Just to understand that once more. It's mentioned about internet. You know, when you advertise on the internet, that's not an offer now.
The internet.
Advertise on the internet.
You're right. It's not an offer. It's an invitation to treat.
So when if someone decides or makes an offer, wants to buy that's an offer.
If you've got something on your website that says you provide these goods and services, and subject to whatever else may be agreed or some other caveats, that you will provide that for X pounds and you will provide that for Y pounds, that is just an advertisement. It's just an invitation to treat. So if someone then tries to go through an ordering process on the website itself, if they place an order pursuant to that particular price, it's still up to you to acknowledge that order and accept it.
That offer he's making.
He's making the offer. You've still got the ability to not accept or accept.
Now I have a deluge of questions. This is good. Yes.
I know it must vary massively, but how much do you see new companies typically spending on legal services right at the start, on the outset, to get up and running?
It varies massively.
Yeah,
Incorporating the company is, if we do it on our electronic systems, it's £250. If you're asking for a set of terms and conditions, it's probably rebated because we recognise where you're at. £500 to £750. If you're talking about a website on top of that,
I think
it's
it's
£500
a tricky
perhaps.
one. I think fees and what you spend it on, you need to think carefully about what you're doing, and you need to think where you're spending that money. So I suppose a question that might be more useful around what you're saying is, obviously people decide not to protect. I think certainly I've had conversations with you in the past where, well, I can protect it, but can I afford to fight it?
Yeah.
So what advice would you give around those areas for these guys who generally do not have deep pockets?
So you have to prioritise. There's no way, rarely can you afford to spend it all in terms of what is theoretically required at the outset. In terms of prioritising anything, I think it's not essential, but I think obviously if you place yourself in a position where you're trading as a company, you've got the benefit of limited liability then. You've also got a slightly more beneficial tax position. So that could well be a wise cost to incur at the outset by setting yourself out. That then, you need to have trading terms. That's the next very important thing in my mind. So depending on how you conduct your business, that may be online trading terms, or it could be both. It could be offline trading terms, or it could just be offline. But either way, you need something that you can then confidently, in a fit-for-purpose way, trade upon. I think intellectual property is clearly a key consideration, but actually if you're in the realms of copyright, it's dealt with automatically. There is no cost, apart from the cost involved in time and energy and resource of getting the works in place and the product in place. A patent, I mean, as you'll have heard from David, is a huge cost. But it may be critical. It may be critical to your cause. It may be critical to your particular case. That's a big consideration, though, because I mean, if you look at Formula One, for example, they don't patent at all. You would imagine them to patent everything, but it takes 3 to 4 years to patent anything. By which time, that design is 4 years out of date. So actually, keeping it secret is all about the way forward in that business, and it's all about competitive edge and maintaining secrecy. So actually, there is a trade-off when it comes to patenting, which you're undoubtedly aware of, which is that you publicly then need to disclose your invention. Then becomes, the world becomes aware of it, and they then begin to know where the current state of prior art is at in that particular industry or that particular sector. Then they can then begin to engineer around it, or heaven forbid, reverse engineer it if you're in a different jurisdiction that's slightly open to utilising other people's intellectual property. I'll say no more than that. But.
Any other questions? No? Brilliant. Okay, thank you very much.
Okay, my pleasure.
Appreciate that.
Thank you very much.